appreciate you joining me today to talk about community mediation and how important it is. As you know, I'm a firm believer in alternative dispute resolution and community mediation. And one of the reasons that's the case is because of how much you've taught me about it. So I want to thank you for that and give you that nod. But why don't you start by introducing yourself, and then we can talk a little bit about community mediation and its importance.
Sure. I'm Judi Teeter, and I'm a professor at Pitt Law School, and Judge Pappas, known to me as Mik, was one of my students way back when. And I teach alternative dispute resolution, among other things. And alternative dispute resolution is about alternatives to litigation. So mediation is one of the biggest ones and most widely used, but it also includes just basic negotiation between people and arbitration as well, which is a more court-like proceeding.
In the law, we're oftentimes thinking of conflicts in terms of legal disputes, but legal disputes are a very narrow form of conflict.
Absolutely.
And so one thing I was always struck by was just this starting point of what are the sources of conflict? And I recall you identifying them as unmet needs. Mm-hmm. And one thing that I saw in district court very early on was that oftentimes what presents in district court as a legal dispute hasn't even matured to a real legal dispute yet, because the parties are pro se, they're without attorneys, they're laypersons, and they don't know the law on which they're filing. They just know that they have a conflict with somebody, and that the place they go to resolve conflicts to get access to justice is the district court. And obviously, as a judge, it's not my position to tell them what their legal claims are. They're supposed to bring those to the court. And so I would see conflicts, I would see unmet needs, and I would see undeveloped legal arguments. And rather than try to interpret what they were telling me their arguments were, I would oftentimes try to say, let's examine unmet needs in a mediation setting potentially. And some of the cases, some of the criteria that I saw early on for good, appropriate mediation referrals were, in particular, parties who would have some lasting relationship after the conflict, right? Family members, neighbors, people who had a conflict that is eventually came into district court forward facing as a legal dispute, and really just needed a third party to help them resolve it. And why not allow that third party, if possible, to be a voluntary consensual mediator, right? A voluntary consensual mediation process facilitated by a trained mediator like yourself and like others who eventually got into the process. And I'm just so grateful for you being kind of there and present and willing to lend your expertise to district court participants.
It was started off as being super informal just because you knew me. And so you, this wasn't even about landlord-tenant, but you called me a couple of times and said, you know, I have this case that I really think would be better resolved in mediation. And the minute, I mean, as a teacher, the minute I see somebody embracing and understanding that mediation is a better solution to many problems, then that's already half the battle, recognizing that you have a process that really works. And so you asked me, and we set up a couple, and I said, sure, I'll do them on a, voluntary, no charge, let's just find a place. And I did a couple of cases for you. They weren't landlord-tenant. There were a couple of, they're confidential. I would never name parties anyway, but I can say what they were about. There was one case where there was a family, an older couple who didn't live in Pittsburgh anymore, and they were renting they were letting their daughter and her boyfriend stay in their place, but they wanted rent and they weren't paying rent. And there was it was a family. They didn't want to be fighting with each other, and they needed to talk, and whenever they started talking, they would argue. So I just sat in a room with them, and in an hour we had the whole thing resolved, and they were happy, and they all were like, yes, and they loved each other, they cared about each other. And then there was another situation where there was a conflict in a very large, very loud family over their father, a whole bunch of siblings, and about the care of their father. And it was the same kind of thing. They all had really strong personalities, but they loved their father, and they all wanted what was best for him. And it was just listening to each other. So a lot of times as a mediator, I think my best job is just sitting back and saying nothing. Once I set the tone and helping people recognize that we will listen to what you have to say, and we will use that and build on it to get a solution. And then I can just sit back and listen. So that's kind of how it started. And then we started talking about the landlord-tenant crisis, and I introduced you to Selena, because Selena, who runs the conflict lab, is, her mediation is her whole career. I mean, mediation is a sideline for me, and while I love it and I'm passionate about it, my full-time job is teaching, and so I can't I couldn't devote the same kind of resources and ideas to it. And Selena has an infrastructure that really can help support this kind of thing. And Aaron also has a passion for mediation and was trying to figure out a path where he could be involved more in full-time in mediation. So getting us all together, the four of us, I remember a few conversations between you and me and Selena and Aaron, and we just started hammering it out. What will it look like? Like you said, what would the protocol look like? And how do I, as a judge, explain this to the parties who appear before me? And you made up a great pamphlet or explanation about, this is what mediation is and this is how it can help you. And then luckily you got and this was not me, and then I kind of bowed out, and this was you and Selena and Aaron getting funding partners and getting it's all about getting a champion, right? You find somebody who believes in the cause and getting the program set up. And it became so obvious that when you talk about landlord-tenant cases, the situation I said earlier about the remedy is key, because all you can do in a situation is order the tenant either out or to pay rent. If the tenant hasn't paid rent and there aren't habitability issues, then the landlord basically wins. And you are in the situation, and even the landlord might not want that. But that's all that the law can offer. Right. But mediation can offer, okay, you can pay me this much per month, or how about you do some work in exchange for rent? Or, there's endless options in mediation for people to get together and talk about what might work and how could we resolve this. I lost my job because of the pandemic, but I know I'm going to get it back, as soon as I can find childcare for my kids, or, there's so many different pieces to it. So there's the ability to believe in the future that something different can happen.
And the law can be so harsh, and its remedies can be so, I guess, unindividualized, like you were saying, right? For example, in a case like the one that you mentioned, with the parents and the daughter living in the home, I can't recall, but I would bet that these aren't folks who know how to prosecute a landlord-tenant case as landlords, right. And that they would make missteps along the way that would require me to, for example, dismiss the case. Well, where does that put them? Right back at the drawing board.
Yeah, they still have the conflict. That's what I mean. They still have the conflict. The conflict still exists.
Right back at the drawing board, right? Or enter an order for possession because they have hired an attorney and they do know how to prosecute the case. It becomes adversarial between family members who do truly love each other. Exactly. And that's why that's a strong element in terms of mediation referrals, at least at that stage. But truly any case can begin with mediation. And maybe even should if the right community infrastructure, so to speak, is in place. And I think that's what we tried to do and ultimately have done at this point in terms of landlord-tenant.
If people have an ongoing relationship, if they're going to have a future relationship with one another, mediation is just ideal, because litigation tends to break down relationships. And what I like to say is that conflict occurs on three dimensions: the behavioral dimension, where you're just feeling like where you're just having a an argument, the cognitive dimension where you just feel like you're in conflict, and the emotional dimension where you have all those different emotions. And in court, the only way that court can resolve, only dimension, is the behavioral one. The court can tell you, stop having a fight because here's what I'm ruling, but it doesn't address those other two dimensions. So it doesn't really fully resolve the conflict. And so that's why mediation can be so helpful. Another thing that courts cannot do is provide individualized remedies. And this is one of the most important, aside from an ongoing relationship, I would say this is the second most important factor, is that in a mediation setting, the parties are the ones that make the decision. Why would you want to have a judge decide some personal issue for you if you could decide it by improving your communication with your other family member, for example? And so the remedies that courts can order, as you well know, are things like money damages or stop doing this, but you can't order somebody to apologize to somebody else. You can't order people to act in a certain manner that is not really part of what the law governs. And so in mediation, you can do that always. Right. And an important cornerstone of the process of referral and the protocol that you were talking about are two things, I think. One, mediation is also confidential, so parties can choose it. I like the idea that you say, well, I'll refer this case to mediation, and if the parties agree, they can go to mediation. The whole thing is confidential, and if they don't resolve it for some reason, they still have the option to go back to court, so they're not really losing anything. That's really important. But as I said, it's what we call a self-determinative process. So the parties are making their own decisions about their conflict. Those are the kinds of basics of mediation that I see as making it so valuable as a corollary to a court. And you're doing it in the district court, but in the Court of Common Pleas, it would be just as valuable, and more so because you have more people that don't have that option.
And what I love about how mediation is framed, or in terms of how it's structured, is that it's empowering because everybody's in the circle. The decision makers are all right there. And mediation empowers people to solve their own problems. It doesn't ask them to leave it to one person, the judge, or to leave it to several people, the panel of arbitrators.
Yeah, to pick up on that, I think it's really important to recognize that mediation not only empowers people to resolve their own conflicts, but it really helps them understand themselves and their conflicts better and recognize the other person as a human in a way. And so the ability to, because one of the most important parts of the mediation process is being heard, each individual having the opportunity to state their case. And as you know, in court, maybe both parties state their claims to a judge, but maybe the lawyers are the ones stating their claims to a judge, not even the parties themselves. Right. So the opportunity to actually communicate with each other is lost a lot of the time in court.
You're right. When the pandemic struck, nobody wanted to go out. Nobody knew what was going on. Nobody wanted to compromise themselves or anybody around them. And the courts were closed at that point, and we were reluctant to go anywhere. There was a stay-at-home order in place. Every place was closed, and what I felt very strongly was that I had to do something. I couldn't just sit still while so many people I knew out there were in anguish, seeking a remedy, seeking a resolution, and particularly in the landlord-tenant context. And so I wrote a memo. I read some articles, and I read Matthew Desmond and him talking about an eviction tidal wave looming in the Washington Post. And I wrote a memo and I said, here's what the problem is. And I sent it to you and Selena and to Aaron, and they ran with it. Yeah. And the memo basically just said, look, not only are we accumulating a backlog of cases that are being continued that have already been filed, but on average in Allegheny County, 1,000 landlord-tenant cases are filed per week. They
Yeah.
can't be filed right now because the courts are closed.
Right.
So not only are we going to have a backlog of filed cases when we do open back up, but we're going to have an enormous backlog of cases that did not have a chance to be filed. And our worst fear was that we would open back up and the next day there would be a line around the block of folks wanting to get into court on a possible eviction claim.
It would
And
be
so,
an onslaught, yeah.
and that was our biggest, fear, and thank goodness it hasn't come true yet. But because we've still got a lot of restrictions in place. But that is to be said, all these resources have emerged in the last year in light of those restrictions, and one of those resources turned out to be this landlord-tenant mediation program. It went from our protocol to a couple meetings, to a completely unforeseeable pandemic, to a memo, and then it went to $30,000 in funding. And then it grew to $350,000 in funding. And it went from being in one little district court out of 46 in the county to being all county, to having partners in 10,000, partners who are landlords with 10,000 units total throughout the county. A 94% success rate, which is consistent with mediation in general, right? And 70 trained community mediators throughout the county and 3 staff. That's unbelievable.
It is unbelievable.
It happened just like that.
Beyond our possible dreams, I think, when we were first sitting around talking about it.
Yeah. Well, I mean, and you know what was amazing to me is that when you have strong community partners like yourself, like Selena, like Aaron, and maybe something of a champion, an elected official, someone with access to institutions, and just the point of view of someone who is within an institution and knows what gaps can be filled in the community side, can see that. It's just really waiting for that chance to that opportunity.
Landlord knows that the tenant owes, there's nothing wrong with the unit. So the landlord goes to court and gets a judgment, puts that judgment in his back pocket. I got a judgment for, $5,000. The person doesn't have the money. The tenant does not have the money. Maybe they don't have a job. The landlord is not going to be able to collect that $5,000. Maybe the tenant has been an excellent tenant in every way, simply has run into some problems. So even with the extra power, the more power, and knowing you're going to win in court, the landlord might be interested in saying, I'm going to keep this tenant because they don't damage the apartment, they're quiet, they're civil, but I want to make a payment plan, or I want to offer some other alternative, or maybe I have a smaller unit that's less expensive and I can move the tenant there. So that's the point. Like, even if you have higher power as a litigant, you still might be interested in, people always have interests that are not just about money.
Yes. And even to your point, even a party who, let's say, has more money, or perhaps unconscious bias may skew in their favor for one reason or another, right? And they might be able to think they can bank on that. Let's use the example of a landlord who knows the process really well, has attorneys on retainer, and has a strong case of non-payment for rent, right? Or end of lease term. Mm-hmm. You might have a slam dunk case when you go to district court, but that doesn't mean that the tenant can't appeal. Right. And that doesn't mean that the tenant can't then, rely on the process to the extent that they need to buy more time to stay in their unit. And that is just so oftentimes the case, and it's costly for even a wealthy, property owner.
Yeah, because they can't turn over their unit as quickly as they would if they, yeah.
And the money matters, right? Because it's a business.
Of course.
And so they're going to be looking for alternatives to that as well. And knowing that there's costs for everybody all along the way, knowing that there's stress and aggravation for everybody all along the way, what I learned through mediation, much through your instruction, allowed me to understand the cases that were coming before me as conflicts, and when they were true legal disputes, and when they were conflicts seeking a remedy short of a legal remedy. And that's largely how I was able to help folks resolve cases through settlement, through agreed dismissals or withdrawals, something short of a judgment for possession. And that's how we took the eviction rate in our district from 90% to 40%.
Yeah, and that takes, requires the right kind of judicial approach. And I think that's terrific.
There's power in people resolving their conflicts and learning how to resolve their conflicts between each other. And sometimes all you need is a skilled facilitator to empower you to do that. Sometimes all you need is an active listener. And if for some reason you yourself aren't able to actively listen, because you yourself have developed strong emotions around a dispute, sometimes all it takes is that third party neutral who's able to sit and listen and facilitate dialogue. It doesn't necessarily require a decision from a judge. It doesn't necessarily require the most harsh remedy that you can think of. Rather, all it really requires is someone like Professor Teeter, someone like Selena Schultz or Aaron Erb, who can just sit down and listen. And now guess what, folks? You have 70 of these folks all throughout Allegheny County trained, able to do this in a landlord-tenant mediation context. So I want to thank Professor Judi Teeter for joining me today to talk about the many wonderful aspects of mediation and how beneficial it can be to the courts and the community. Thank you very much.
Thank you so much for having me come in, and I'm really excited about people learning about the power of the mediation process. And I thank you for bringing it out into the community. It was great to talk with you.
You too. See you soon.